Welcome everybody. My name is Sabba Mirza and I'm a Senior Associate in Fieldfisher's Privacy, Security and Information Law team, and I'm joined by David Lorimer, who is a Director in our team. This is part of our Get Data Protection Fit series. The series has already taken you through Module 1, the Fundamentals of Data Protection Law, and Module 2A, Putting Data Protection into Practice. This is the first segment of Module 2B, which also focuses on putting data protection law into practice. Today we are looking at Data Subject Access Requests, or DSARs. I've received a DSAR. What next? By the end of this session, you should be able to be prepared for a DSAR and respond to a DSAR. We will start off by looking at what the right of access by a data subject is. We will then consider how you should prepare for a DSAR, the key steps in responding to a DSAR, and practical steps when dealing with an employee DSAR. Individuals have the right to obtain the following from a data controller: confirmation that you are processing their personal data, a copy of their personal data, and other supplementary information which corresponds to the information that you would ordinarily supply in a privacy notice. So how do you prepare for a DSAR? We have set out on this slide some of the items that you should consider and implement to enable you to deal with a DSAR. I have already mentioned that the information that you provide with a copy of the data when responding to a DSAR corresponds to the information contained in the privacy notice. Therefore, it is essential that you have a privacy notice in place, particularly because you will need to provide a copy of it as part of your DSAR response. It is helpful to have a documented step-by-step procedure in place to allow you to deal with a DSAR efficiently. You should know who the data custodians within your organization are and what data they hold, as this will assist when searching for and collating the data requested by the data subject. If you are a business that typically receives a lot of DSARs, it would be helpful to have template responses in place, such as an acknowledgement letter and the response letter. This will save time and money when dealing with a DSAR. Here are the key steps that you will need to follow when dealing with a DSAR. You will note that we have a star next to steps 2 and 3. The reason for this is that, depending on the nature of the request, you may or may not need to follow these 2 steps. The first step is to consider the request itself. You will need to identify whether the request is a DSAR. It is important to note here that for a DSAR to be valid, you do not need to cite Article 15 of the GDPR or say that you are making a DSAR. A DSAR also doesn't have to be in a formal letter. It could be made by telephone or even on social media. Some requests for data may be standard business as usual requests, for which you can rely on an existing business process in order to respond to them. For example, an employee does not need to make a DSAR to obtain a copy of their employment contract. They can simply ask HR for it. You may also be able to get an extension to respond to the DSAR if the request is complex or if you have received multiple requests that you need to deal with. You should consider guidance from the regulator before seeking an extension under these grounds, but this would be something that you consider at this stage. Also at this stage, you should consider if the request is manifestly unfounded or excessive. I will discuss more about this in the following slide. If you have doubts about the identity of the person making the request, you can ask for information that would help verify and confirm their identity. You do not want to accidentally give information to an imposter that's actually about somebody else, as that would cause a data breach. You must let the requester know as soon as possible that you need more information from them in order to confirm their identity, and you must only ask for information that is necessary to confirm who the requester is. Proportionality is key here. For example, if you're a business that processes device information and an individual's activity on games that they may have downloaded on their phone, then you may ask for device identifiers that would help match the information they provide against the information that you hold on them. The clock also starts once you have confirmed the individual's identity. The next stage is to consider the scope of the request. Essentially here we need to consider what the requester has asked for. Are they looking for a particular piece of information about them? Have they provided date ranges for the information that they require? Practically, you do not want to spend time and money giving a requester information that they haven't asked for. You can limit the DSAR to just providing information held at the time the DSAR was received. For example, if the DSAR was made on the 1st of July 2020, you only have to provide information up to that date to the data subject. Where you've got large volumes of information about the individual, you can go back to the individual and ask them to clarify if they are looking for something in particular. You can also ask them for keywords and date ranges that would help identify and locate the information that they are looking for. Another important thing to consider is the deadline. Article 12.3 of the GDPR states that you have 1 calendar month from the date the DSAR has been received to respond. Now this can be extended by a further 2 months for complex and multiple DSARs, and we discussed this earlier on in the session. But if you are looking to seek an extension, you should let the requester know as soon as possible within the first initial month. Also, if you are going to reject the request, then you must also let the data subject know as soon as possible within the first month. There are 2 main grounds under which a response could be refused. The first is if the request is manifestly unfounded. That means that the individual clearly has no intention to exercise their rights of access, or the request is malicious in intent and is being used to harass an organisation with no real purpose other than to cause disruption. Another ground for rejecting a request will be if the request is excessive. A request is excessive if it repeats the substance of previous requests and a reasonable interval has not passed since the first request was made and responded to. A request is also excessive if it overlaps with other requests. Before you rely on these 2 exemptions and refuse the data subject access request, you should consult and seek the regulatory guidance on this point. The next step after considering the items we have discussed in steps 1 to 4 would be to acknowledge the request. You should write to the data subject to confirm receipt of their request, the deadline for the response, ask to confirm their identity if this is required, and ask them to clarify scope and provide additional keywords and date ranges in order for you to locate the data if that is necessary. You will not need to clarify the scope where the request is already very specific. Now is probably one of the most vital stages of the data subject access request, and that is to carry out your searches and to collate the data. When searching for the personal data, you should consider the application of keywords, date ranges, and data custodians, especially for electronic searches. You should involve the requester in this if appropriate, as I mentioned on the former slide. If it's a very large volume DSAR and you've got a lot of data to go through, you may then consult the requester and ask them if there's anything specific that they're looking for, or for additional information that would help identify the information that they have requested. You can rely on internal or external analytics and document review teams and providers to help you with this stage. You must also draft and circulate appropriate guidance where physical searches will be carried out by people. For example, if you're going to have members of staff go through their mailbox to search for information relating to the requester and their DSAR, you must provide them with a step-by-step guidance in terms of what they should look for. The next stage of the process is to review and redact the data that you have collated about the individual and that is in scope of the DSAR. You should consider the following questions when deciding which information should be redacted and which should be disclosed to the requester. The first and most obvious point is to consider, is the data in question actually the requester's personal information? Now, this becomes key in probably some of the most basic circumstances. For example, you may have several employees with the same name or the same abbreviation of the name that they use. So when you collect the data as part of your searches, you will then need to consider and sift through the information and see which information actually relates to the data subject and which relates to a third party. You will also need to consider whether the information is in scope of the request. As I mentioned earlier in the session, that some of the information may fall outside certain date ranges, so therefore it would fall out of the scope of the DSAR. You should also consider whether the information you're looking at is actually a duplicate of data that you're already going to provide the individual. So where you have a copy of the same email chain several times in the dataset, you only need to provide just the one email chain. When considering the documents that you have in scope for the DSAR, you should consider whether it's wholly or partially exempt from disclosure. And here we will also think about some exemptions that I will talk through in the next slide. You should think about which content should be redacted. Again, exemptions come into play here, and we would also redact information that's business sensitive or purely irrelevant and not related to the data subject. You should also think about data that should be flagged at this stage. And this is mainly looking at information that's not really subject to an exemption, but could otherwise cause concern to the data controller. For example, has a colleague said something derogatory about somebody who has left the organisation and then made a request? While that's not strictly subject to an exemption, you may want to know about it to see whether the information should be disclosed or not. Here are some more common exemptions that you might use when dealing with a DSAR. The first is third-party data. Now, the individual making the request is only entitled to their own personal data, not the personal data of a third party. Generally, you will be able to redact third-party data when dealing with a DSAR. However, in some circumstances, you may need consent from the third party before disclosing their personal data. In the event that they don't consent or obtaining consent is not possible, you as the data controller will need to consider if it is reasonable to disclose the third-party data without their consent. When making this assessment, you should consider the type of data that is going to be disclosed, any duty of confidentiality owed to the third party, the steps taken to seek their consent, whether the third party can actually give their consent, and any express refusal of consent. Data that may prejudice ongoing negotiations is also exempt from being disclosed in a data subject access request. The third commonly used exemption is management forecasting and planning. Again here, information is exempt to the extent that compliance with the data subject access request would prejudice the conduct of the business or activity in question. The last two exemptions here are what we typically see in rather contentious data subject access requests. Legal advice privilege. This exemption applies to confidential communications which pass between a client and the client's lawyer, and which have come into existence for the purpose of giving or receiving legal advice about what should prudently and sensibly be done in the relevant legal context. This exemption is narrower than the litigation privilege exemption, but can be claimed more commonly. The litigation privilege exemption must, in most and arguably all cases, be a confidential communication, between a lawyer and the client, or between either of them and a third party. It could also be a document created by the client's lawyer or on behalf of the client, which is to be used for the dominant purpose of litigation and relate to litigation which is pending, reasonably contemplated, or existing. To the extent that any of these exemptions apply, the data will not be subject to disclosure as part of the data subject access request. The last step here is to respond to the data subject access request, and we have listed the specific information that you are required to provide the data subject when responding to the data subject access request. As mentioned, this is similar to the information that is provided in a privacy notice. When responding to the request, you should also explain which exemptions have been applied and why. I will now hand over to my colleague David, who will give some practical tips on dealing with employee data subject access requests.
Thank you, Sabba. Employee DSARs can be particularly tricky and very prevalent. The rules Sabba has helpfully set out apply equally to them, but there are particular points to be aware of when dealing with them. The challenges of employee DSARs will of course depend on the circumstances, but typically include those listed on the slide. Briefly, the issues include problems with finding and disclosing unstructured data, sifting communications data, including instant messages and emails, and deciding whether non-networked communications are captured, considering whether a request might be an attempt to obtain a smoking gun or some early disclosure of documents. Now on to some practical tips when dealing with employee DSARs. As I've said in the slide, the initial response is absolutely key. Explaining the entitlement helps manage expectations in my experience, as employees often submit DSARs expecting the disclosure of documents, including, for example, comparative salary spreadsheets and board minutes where they're the number one topic. The reality, of course, is different. They're entitled to personal data, not documents, and it can help to clarify this at an early stage without, of course, obstructing their right. ID checking employees can be a sensitive subject. It should not be done where you don't need to, as Sabba has explained, but if a DSAR comes from a private email address you don't recognise, or from a legal firm, it might be appropriate and necessary to ask for confirmation. On timing, of course you'll know that you need to handle the request without undue delay, and in any case within 1 month of receipt of the request, and that you might extend that period by up to 2 months where necessary, taking into account the complexity and number of requests. Often, in reality, employee DSARs are complex, and that's often because they involve lots of communications data, which typically involves 3 data subjects: the sender, the recipient, and the subject of the communication, and which is frequently confidential and sometimes privileged. Reviewing large volumes of communications to consider the application of multifaceted exemptions is often complex, and that can trigger the need for extra time. So my tips here are, try and work out the volume of data that you would be dealing with in response to a DSAR and the time it would take to review that volume of data. When you communicate that, it can also make any request for further information more compelling. Also, give reasons. Tell the employee why the response will take longer, but don't ask for that longer period. On further information, Recital 63 of the GDPR sets out that where an employer processes a large quantity of personal data, they should be able to ask the employee to specify the information or processing activities to which their request relates. The aim should not be to narrow the scope when asking for further information, but of course that might be the result. That can be helpful when dealing with broad scope, disclose everything you have on me type requests. Often employees will be willing to clarify the issues they want to see data on to inform keywords. date ranges, and even custodians, i.e. creators, senders, and recipients of information, all of which makes life easier for the controller employer. Consider the wider context. Often there's a dispute, or at least the threat of a dispute in the background. Make sure the team working on the DSAR response is aware of the wider context. Decide who will lead the communications with the data subject and whether that should be the same person dealing with the dispute. It's also sensible to consider whether some additional value might be extracted from the data review when you do it, to inform risk assessment, strategy, and even to assist disclosure in any court dispute. It's very easy these days to use review platforms to flag particular information in documents that might help inform strategy. Of course, that won't affect whether the information is disclosable or not, but it can always be helpful to be forewarned. Particular care needs to be taken not to escalate a dispute or to provide another cause of action. For example, I've seen employees plead in employment tribunal claims that a failure to comply properly with an in-employment DSAR fundamentally breached their employment contract or amounted to an intentional detriment. So beware of that. Finally, be particularly live to accept exemptions. Failing to apply the exemptions properly can significantly undermine the employer going forward. So for example, a failure to exempt, including by using redaction, third-party data, can lead to upset amongst and even claims from third parties identified. Disclosure of negotiations data, commonly without prejudice or off-the-record negotiations with data subjects, can of course undermine a settlement strategy. Disclosure of legally privileged advice in response to a DSAR can amount to a wider waiver of privilege in relation to any dispute, so that's certainly to be avoided. On to some of the key takeaways from this session then, which include having in place a process and policies to deal with DSARs when they do arrive, and ensuring those responsible for administering them understand their role. The phrase fail to prepare or prepare to fail is never truer than when unexpected data subject access requests land. One good way to test the value of procedures and to upskill those involved is to carry out a tabletop or simulated DSAR. Secondly, know who your custodians are, i.e. those creating the data that might respond to a DSAR. Beyond that, it's important to understand the information architecture of your organisation, what platforms hold the data that might respond, and how those might be used to find it. Be mindful of the timelines. Remember that the rule is that access is to be provided without undue delay. The 1 month and 3 months where applicable timescales are long stops. In practice, data subjects are often inflamed by late compliance and may complain to the relevant supervisory authority, so you want to avoid that. Finally, retention and deletion is a subject for another day, but of course the process of finding, reviewing and providing data is much easier when organisations are good at ensuring data is deleted when it's no longer needed. Hopefully you'll now feel more confident in dealing with DSARs and that you understand the requirements of a DSAR, understand the importance of having a subject access request procedure in place, and know how to deal with the DSAR and navigate some of the more tricky issues that arise in practice. That's it for this session. Thank you very much for joining. If you have any questions about the subject, please don't hesitate to contact us using the details on this slide.